Hi friends, welcome back to my channel. This is Durbadal once again. In today's video, we will talk about NDA or Non-Disclosure Agreement. In today's competitive business environment, if you want to enter into a new business relationship or an alliance relationship, which is a partnership relationship, the first thing that you probably need to do is participate in a competitive bidding process. If you want to do that, in most cases, the first document that you would need to sign would be an NDA. NDA stands for Non-Disclosure Agreement, which can also be called as Confidentiality Agreement. And the purpose of this document is to protect any confidential information shared under the umbrella of this document. Sometimes this document can get tricky, and if you do not have the knowledge of what are the things that you need to watch out for, if you end up signing the document without understanding, you may find yourself later to be in breach, which is you're not able to comply with it and you have somehow violated the provisions of this document. And in such case, you may get sued by the other party claiming breach of contract. And as you know that this is the purpose of this document is to protect confidential information, which may include trade secret. You may be in a position where the other party is claiming that you have misappropriated trade secret or have infringed a copyright or have used unfair means in the competitive bidding process. So let's understand this better. What are the things that you need to watch out for when you are reviewing an NDA, and before you sign an NDA, you at least need to read through it. So the first thing that would be there in the NDA document is you can make out whether it is mutual or unilateral. What is mutual? Mutual means both the parties have a right to disclose information, and both the parties, when they disclose the information, will be protected under that agreement. The other form is unilateral, which means only one party's information will be protected under the agreement. So you need to understand whether both the parties are sharing information, and most importantly, the information that you are sharing, whether that is protected under the document. Second is the purpose. It is every confidentiality agreement is specifically drafted for a purpose. If it is a competitive bidding process, the purpose will be specific to that bidding process. If your confidentiality agreement is for a specific business relationship, then that will be the purpose of the NDA. The next thing is the definition of the confidential information. You need to make sure that the information that you will be sharing is covered under the definition of confidential information. Now that brings us to one important thing, which is called the marking requirements. There are some NDAs, I would say most of the NDAs would require any information shared under the confidentiality agreement to be marked as confidential. By marking as confidential, it means anywhere in the document that you're sharing, it should be written confidential, whether it is in the footer or the header or as a watermark. Your document should be somewhere, there should be a legend of confidentiality in the document that you're sharing. The next thing is obligation to protect. So there will be a clause which will talk about the degree of protection of the confidential information offered under the agreement. Usually, this is the clause would state that the receiving party will offer reasonable treatment or reasonable degree of care to the information shared by the disclosing party, and that should be no less than the degree of care a receiving party offers to its own confidential information. But in few NDAs, it may also be the security levels, or it should be it can also state that the information should be password protected. So it really depends from NDA to NDA, but there will be a clause around the obligation to protect. Now, related to that, there will be language on the permitted disclosure. which means that the information which is confidential when received by the disclosing party, the disclosing party can share that information with its business alliances. Maybe it may be their employees or their shareholders or their advisors, consultants, tax advisors, legal advisors. But the basis of that disclosure to the third parties or their internal parties will be on a need to know basis and on a confidential basis, which means that whenever such information is shared with such party, the receiving party needs to make sure that there is enough protection in the form of maybe a written agreement that the other party will protect the information that's been shared. There are some other scenarios when it will be permitted to disclose a confidential information. For example, when there is a court order requesting disclosure of certain confidential information, and in such cases usually the requirement is that the receiving party will have to inform the disclosing party in advance and should apply to such government authority a protective seek protective order in order to protect the confidential nature of that information that's been shared. The next thing is exclusion. We need to understand that in order for an NDA to be enforceable, not all information shared can be treated as confidential. There are certain information which may be available in the public already, or some information which the receiving party is already aware of. Those information cannot be treated as confidential information. Now, the next thing is usually an NDA will not have any implication on the IP rights, which means that an NDA signature of an NDA will not amount to licensing or licensing of IP rights or transfer of IP rights. There usually will not be any warranty. Whatever information shared will be on an as-is basis. The next thing that we need to understand is the term. The NDA usually should be bound to a specific term or limited to a specific term. Now, by term I mean the term of the confidentiality agreement, but that is separate from the period of protection that should be offered to a confidential information shared, which is also called a protection period. Usually this period is separate from the term of the NDA, and what is expected from the disclosing party is that information should be kept confidential till the time it becomes publicly available, which basically means that the receiving party needs to keep it confidential for an indefinite period of time until that information automatically comes into the public domain, or the value of the information is no longer confidential. Now, from the receiving party's perspective, that may not be reasonable, and they may want it to be limited to a specific period so that it is easier for the receiving party to comply. Return of data. Usually once the confidential agreement is expired or is terminated, the information received under this agreement needs to be returned to the disclosing party. And then in the current situation, when we know that personal information or personal data is extremely important, what are the laws that it needs to comply, and the mechanism under that specific law that the parties needs to be aware of. And then the boilerplate clauses, for example, the governing law, dispute resolution, assignment, so those kind of clauses will be there. Lastly, there are certain NDAs where we see an obligation of indemnity, which means that if the receiving party uses the confidential information or discloses the confidential information in an unauthorized manner, then because of that the disclosing party incurs a loss, then the receiving party needs to indemnify the disclosing party for it. Now, this this is a highly negotiable point. Usually it is, I wouldn't say that is a market standard, but if there is any, then needs to be dealt in a specific on a case by case basis. That should be pretty much it. And whenever you're signing an NDA, you need to look out for these clauses, which are the the basic elements of an NDA, and you need to ensure that you are fully protected, and your information that you'll be sharing under that NDA is also protected. The last thing that I need to talk about is the enforceability of an NDA. Now, if I talk about, if I consider the Indian perspective, under Indian law, NDA is protected, unless and until there is some restrictive trade covenant, which usually is found in a employee-employer NDA. But in cases of business transactions, the NDA are enforceable as long as there is evidence, or there is inference that such NDA was signed in order to get into a strategic or a larger business transaction or a larger business relationship. And so from the enforceability perspective, the things that are important is that the NDA should not be overly broad, which means that the term, the purpose, the definition should be limited and should be specific. But we need to also understand and remember one thing, that if there is a breach of NDA, then the party who is seeking to enforce the NDA has the ownership or the burden to prove the breach and the quantum of the loss. So with that, I think I have given some detail or information to you regarding what an NDA is, its usefulness, and the things that you need to watch out for when you are signing an NDA. Hopefully you will find this video helpful. Let me know if you have any questions in the comments box below. Thank you for watching. See you again. Bye-bye.